Thank you, Julie and Mary, and thank you to Inclusion Ireland for the invitation to speak to so many of you this morning. It's really great to see the level of interest. As Mary mentioned, I'm joined by my colleague Patsy Fitzsimons, who, so I do see some familiar faces and names on the screen before me, and indeed the presentation that I have today may be somewhat familiar to some of you who have heard me speak before. I will also say that a presentation very like this one is available on our website, and you'll also find there a more detailed presentation which provides some further information in some kind of drilled down detail on the Assisted Decision Making Capacity Act and the Decision Support Service. So let's begin. As Mary said, this presentation takes something like half an hour, maybe a bit less, and I hope that allows plenty of time for questions. All right, I'm sure somebody will shout if this isn't working, but let's press on. So the first thing to say about this new law, the Assisted Decision Making Capacity Act 2015, is that it has already been fully signed into law. So that happened after a really long lead up. And Inclusion Ireland, I know, was one of the important contributors and lobbied hard for this important change in legislation. As I'd been saying then, President Higgins signed the Act fully into law right at the end of 2015, and Inclusion Ireland was a key player in ensuring that this important legislative change came about. So what do we mean when we talk about capacity under this Act? Because capacity can mean some different things in different contexts. But here we mean the your decision-making capacity, the ability to make your own decisions. So this Act, and I'm just going to call it the Act throughout because it's got a big long name, but the Act is about how we support people to make their own decisions independently and provide formal supports where that is necessary. One thing to note is that the Act is only about people who are over 18. In some other places, there are different laws which have 16 and 17-year-olds provided for separately. But here we're only talking about people over the age of 18. And maybe that's something that will be revisited and changed in the future. That should say the plan. Look at my bad. Oh, hang on. The plan is that the Act will start working in the middle of this year. So the Department of Children, Equality, Disability, Integration and Youth is responsible for the Act. It used to be the Department of Justice, and the Minister for Disability, and that's Minister Anne Rabbitte, has very recently and very openly committed to beginning the Act next month. So we really are almost there. There's a bit to be done before then, not just thinking about the DSS getting ready, but just to keep things interesting, the Act itself is going to be changed a little. There is amending legislation which is currently making its way through, but if there are any important changes that we're aware of already, I'm going to mention them as I go along. But most of what I say is absolutely going to be unaffected by those few changes that are to come with the amending legislation. But that's a big final piece of the jigsaw, and it's being progressed by the department. And why do we need a new law? Well, the law that we currently use is really old. And I'm afraid it's called the Lunacy Regulation Act of 1871. So big problems with the language in the Act and what it does. And that is an old Act that regulates wardship. You might have heard of the wards of court system. Some of you might be wards of court, I don't know, or you may be familiar with people who are in wardship. At the moment, there are about 2,200 adult wards of court. And just thinking about them, they would comprise people with intellectual disability, acquired brain injury, mental illness, or forms of dementia. The biggest single category actually would be older people with one form of dementia or another. So there are 2,200 adult wards of court at present. And when the Act fully begins, there will be no new applications for wardship. And all of those 2,200 people will come before the wardship court. They will have their cases reviewed by the wardship court. And one way or another, they are all going to leave wardship within 3 years of commencement. Now, in some cases, the wardship court may simply send them on their way with their property and their decision-making independence fully restored to them. And in other cases, the wardship court might think it is appropriate to move them onto one of the new supports offered under the new Act. And all of that is being managed by the Office of the Wards of Court. So we in the DSS are not really directly involved. There was an important milestone actually a couple of weeks ago, because the Office of Wards of Court said that they were not going to take in any new non-urgent applications for wardship. And the thinking there was that any such applications, if they began that late, weren't going to be finished before the new Act comes in. In wardship, the court can declare you to be of unsound mind and incapable of managing your affairs. And that can be in relation to a big decision. And often people are made wards of court to look after one significant decision. It could be around inheriting property, getting a large award of compensation, for example. It might be about a big medical or treatment decision. But when you're made a ward of court, then not just that big decision, but some small decisions, all of your decision making in relation to minor and unrelated matters is taken away from you. When I was a solicitor and in practice, I acted for a woman who was made a ward of court because she received a large amount of compensation from a state tribunal. It was hundreds and thousands of euros. And she then didn't really mind the idea that the court was going to look after that money for her and make decisions around it. But she would complain to me, well, why is the president of the High Court, who has never met me, deciding about minor medical treatments or even applying for a passport, going abroad with my family, or giving small amounts of cash to my children and grandchildren? That's the effect of wardship. And as I've said, there won't be any new wards and everybody's coming out of wardship within 3 years. So these are some things that the new system and the new Act does. It talks about how we look at a person's capacity. And as I've said in one of the circles here, you lack capacity is not a full sentence. If you think about wardship, the wardship court can say to a person, you are a person of unsound mind. It's like a badge. But here, you lack capacity is not a full sentence. It has to be about capacity to decide a thing and to decide that thing at a particular time. So it's not actually a medical test. We're not looking at, does somebody have an acquired brain injury? Does somebody have dementia? Does somebody have an intellectual disability? That only matters if it is actually impacting on your decision making. So these are the features then of that functional test. If you think about the decision that you might need to take, if you use my example, then it might be about managing 400,000 euro that you've received in compensation. Can you understand the information about making that decision, the decision about how to manage and invest and look after that large sum of cash? Can you retain that information for as long as you need to in order to make decisions? Weigh up and use that information and then communicate your decision. Now, thinking about communication, it's communication with whatever supports you require. So you may need assistive technology, you may need sign language, you may have your own particular communication tools that you rely on, and those should be available to you. And the fact that they are required is no indication that you lack capacity. So these are the 4 elements that are looked at. If you need to, you don't rush to assess anybody's capacity. But if a functional assessment is being carried out, these are the key elements of that assessment. And as I've said already, anything to do with your diagnosis or your presentation isn't actually relevant unless it is impacting on how you decide. It's about ability and not disability. If you think about the title of this Act, and it has a big long title, Assisted Decision Making (brackets Capacity Act. Notice the brackets around capacity. This Act was going to be called just the Mental Capacity Act, but there were arguments that that name didn't really reflect what the Act was supposed to be all about. And I'm sure this is something with which Inclusion Ireland would agree and perhaps argued back in the day. Because it isn't fundamentally about assessing a person's capacity or finding out about their consent or about trying to fit somebody into the new framework that I'm about to describe to you. Fundamentally, this is an act about supporting people to make their own decisions by themselves as far as they can. So it's not about a person's disability, that's over to one side. It's really about their ability and maximising abilities. And that's dealt with in some of the guiding principles under the Act. So these are some of the most important things to remember. We start off by thinking that everyone can make their own decisions, and this is called the presumption of capacity. And this is the law already, actually, and the Act is just writing it down and putting it into what we might call black letter law and Act. So any adult is presumed to have capacity to make their own decision, unless you can show that they don't, and you're showing that they don't in that functional way that we've just spoken about: understand, retain, weigh up, and communicate. So the starting point is that a person can decide. Doesn't matter if this is somebody with an intellectual disability, acquired brain injury, whatever it might be, the starting point is that they are able to decide. And indeed, as I say here at number 2, you have to give people all of the supports that they require to make their own decisions before you rush to conclude that they don't have that capacity, before you even think about assessing their capacity. Support them as far as possible to make their own decisions. This one can seem a bit challenging. I'm looking at number 3 here. Deciding to do something unwise doesn't mean that you do not have capacity. Sometimes people call that the right to be unwise. We all do unwise things sometimes. We don't have an unlimited right to do unwise things. What the Act actually says is that wanting to do something that seems unwise or deciding to do an unwise thing doesn't mean that you lack capacity, unless there's other evidence that would lead you to think that. So the fact that I want to do something that seems reckless or full of risk doesn't mean that I lack capacity. If I've always been a very careful person, then maybe those around me who are involved in this decision making might think, well, okay, is this a reason to put in place further supports to assess capacity or to look to the formal supports which are available under the Act? But it isn't evidence by itself. These are some more of the guiding principles. The Act talks about the importance of intervening as little as possible. I can remember meeting a lady who has dementia, and she was talking about this Act and what's important for her. And she said, it's like when you're crossing the road and people grab your arm and you're saying, I don't need you to grab my arm. I can do this by myself. So it is about knowing when to intervene and knowing when to step back. And the starting position isn't to jump in there and try to do things for people. It's about respecting everyone's dignity, privacy, bodily integrity, autonomy, and the right to look after your own property. Letting people make up their own minds as much as possible and including the person in decision making. I put the next one in red because the United Nations Convention on the Rights of Persons with Disability and the UN Committee for that convention really emphasise this next point, which is about respect for will and preferences. So instead of looking at somebody's best interests, you start with what they want, not what's good for them. And you give effect to a person's past and present will and preferences as far as possible. And you might find out about a person's will and preferences by talking to other people close to them, who know the person and their beliefs and values and what they would want. At the same time, acting always in good faith and for the person's benefit. So what sort of decisions are we talking about here? What are the sort of decisions that can be supported under the Act? Well, they're divided into 2 categories. You have personal welfare and property and affairs, and they cover a lot of things between them. So personal welfare might be about deciding where you live and who takes care of you. It could be decisions around training or accommodation, access to social services. It might be about healthcare decision making, like if you're going to have an operation. And then on the other side, you have property and affairs. So this could be about buying or selling property, renting property, looking after your money or bank accounts, providing for other people or applying for benefits. Both categories, property and affairs and personal welfare, cover pretty well everything that you might have to make decisions about. And this is the new framework to support a person in making those decisions. And I'm going to go through each of them in turn. At the lowest tier then is the decision-making assistant, or DMA. The middle tier is the co-decision maker, which you might hear me call CDM. And then at the top tier, and this is where the court gets involved, is the decision-making representative, or DMR. So the first one then is the decision-making assistant. So you, the person, are choosing somebody whom you trust, whom you have a pre-existing relationship with, family member or friend, somebody who's going to help you then gather up information and understand that information and the choices that you have to make. So this is your DMA, and you set all of this out in a decision-making assistance agreement. So your decision-making assistant helps you to get the information you need and explain it to you if necessary, helps other people know about your decision and help you to have it carried out. You're always making the final decision yourself. Now, there is one exclusion here. If you are somebody in residential services, there's actually a few exclusions. This has to be somebody who's overall suitable to do the job for you. But one matter that might be of interest is that if you are somebody in residential services, then the owner or the provider or an employee of those services is not authorised to be one of these, to be your decision-making assistant. Sometimes that prompts a bit of discussion, but that is what's there in the Act at the moment. At the middle tier then is the co-decision maker, or CDM. Now again, you, the person, are choosing who this might be. Somebody whom you know and trust, like a close friend or a family member, and you're deciding that you are now going to take certain decisions jointly with this person, and all of that is set out in a co-decision making agreement. And that co-decision making agreement is sent to us in the DSS. There are other pieces of supporting documents that you have to send with us. Our website and our platform, our portal, will show you how you make one of these co-decision making agreements. So when you are working with a co-decision maker, your co-decision maker helps you again to take up information and helps you to understand it. There are rules for them to follow. They have to apply the guiding principles. All of these supporters have to apply those guiding principles that I've mentioned. There's a rule that the co-decision maker is not to stand in your way. So they have to give way to what you want to do, but that's unless there is a risk of serious harm to yourself or somebody else. They have to act within the co-decision making agreement. So if you have made a list of things 1 to 5 that they're going to decide jointly with you, then they don't get involved in matter number 6. Again, like that DMA, if you're in residential services, then the owner or registered provider or an employee of those services isn't able to be your co-decision maker. And once all of this is done and registered with us, you take those specified decisions jointly. Okay, at the top tier then is somebody called your decision-making representative. And this is somebody who is appointed by the court. So this all starts with an application to the circuit court. If you know the wards of court system, you will know that that's usually the High Court. It's almost always the High Court. But from now on, if you do need to go to court at this top tier, then it will be the circuit court. And the idea is that the circuit court is local to you, it's more cost effective and more accessible. So anybody can make an application if they are somebody who has a bona fide interest in the welfare of the person. Actually, the relevant person can make their own application to clear up an issue around their capacity. So you're asking the court to decide whether the person has capacity to decide a number of specific matters. So it's not like wardship. Remember, wardship can cover all of those decisions, even the ones that aren't really a problem. With this, you are asking the court to look at the person's capacity in relation to specified matters. And if the court believes and rules that you don't have capacity to take those decisions by yourself, it can appoint this person the decision-making representative. Now, the court has to consider a number of matters there. It has to consider whether the lower tiers of support would work, because again, remember that principle about only intervene as far as you need to. The court will look at the complexity of those decisions. The court will look at your existing family relationships. The court will look at any support that a proposed family member or friend who wants to be DMR, the supports that they will have to help them. And if the court finds that there is nobody available or suitable or willing to step into this role, then the court can appoint a decision-making representative from a panel that we will hold in the DSS. And these DMRs then report to us in the DSS. So whether they come from our panel or whether there's somebody belonging to you, they have to file reports with us, and we will work with your decision-making representative to make sure that all of that goes well. Again, the exclusion if you are in residential services applies here. Now, planning ahead. So everybody should think about planning ahead if they can. And the idea is that when your capacity is completely fine, you can put in place arrangements that will come into effect if you're not able to make things, not able to decide things for yourself in the future. So in an enduring power of attorney, you set out what sort of decisions your attorney is going to be able to make on your behalf if you can no longer do so in the future. And all of this obviously only starts working at the point when you can't make decisions for yourself. The other important tool for advanced planning is the Advanced Healthcare Directive. Now, these exist already, and people have them and they are respected. But here the Act is, again, putting something into black letter law. So an Advanced Healthcare Directive is a legal document, and in it you can set out your wishes about medical treatment so that this gets opened and must be followed if you no longer have the capacity to make those particular treatment decisions for yourself in the future. In your Advanced Healthcare Directive, you can choose a new person called a designated healthcare representative. So they are a person that you know and trust, who is going to ensure that if you are no longer able to make these decisions for yourself around treatment, they will ensure that people know that you have an AHD and that it is being respected when it comes to refusing certain treatment measures. The Decision Support Service. So this is us. We're a new service set up under the Act. As the Act was making its way through, this was another one of the changes that was made. The Decision Support Service was going to be called the Office of Public Guardian. If you know anything about capacity legislation in other countries, you might know that an office a bit like ours is often called the Office of Public Guardian. And we were going to be called that, as I say, but the name change was made because, again, the idea was that it didn't properly reflect the whole ethos of the Act and what the DSS will do. If you think about guardianship, it sounds quite paternalistic. It sounds like it's about protecting people rather than supporting people in their decision making. And that was the reason why we became the Decision Support Service. We were going to be in the court service. That change was made very late in 2015, so that we are in the Mental Health Commission, but we have a completely different job from the rest of the Mental Health Commission. Our colleagues on the other side of the house, as we sometimes put it, have their duties under the Mental Health Acts, and we have our duties under the Assisted Decision Making Capacity Act. Even though we're part of one and the same organisation, we have different roles. And as I say here, coming soon, from what we hear, the Act is due to be commenced in the next month or two. And then we will be coming fully to life. So up to this point, we have been getting ready and putting in place the organisation that will be the DSS. So we've had to think about all the different functions that we have under the Act, about putting in place processes to support those, about building an ICT system, designing an organisation, recruitment, procurement, all of those things, and also codes of practice, which we published recently, and they are to be finalised and be published before we are fully up and running. So what do we do? Well, these are some of the jobs of the director of the DSS and my team. So our job is to let everyone know about supported decision making, to tell people about how they can be a decision supporter. I mentioned those decision support arrangements coming to us to be registered with us. So we will have a register of decision support arrangements, which people will be able to search within certain rules. If you think about it, if somebody presents and says, I'm the co-decision maker here, it's going to be important to know that they really are and what they're really authorised to take decisions jointly about. And you can find that out from the DSS and by looking at our registers within certain rules. We have a duty then, as I've said, to support decision supporters, to supervise decision supporters, but our focus is going to be on supporting them to be the best supporters that they can be. So a co-decision maker, a decision-making representative, and an attorney file reports with us. They have certain compliance duties, and we will work with them to make sure that all of that is going well. And perhaps where it isn't going so well, we can investigate complaints about those decision support arrangements. So Patsy, who joins me here today, is the head of our complaints and investigations section, and we can take complaints about a range of matters. Perhaps your co-decision maker is doing more than simply acting jointly with you and is trying to decide things for you, or perhaps they are trying to decide things that aren't covered by the arrangement at all, or they might be doing so in a way which doesn't respect the guiding principles. Those sort of things can come to us by way of complaint, and we will look into it. We have certain powers to do that. We have powers to resolve matters informally. But all of this is with an eye on the rights of the relevant person. As I think Mary said at the start, there's a lot to get used to here. We expect that not everything will necessarily go smoothly because it's unfamiliar at the start. And we have a job in the DSS to make reports, to make recommendations to the ministers about how things are going and perhaps how they can be made work better. Safeguards are important under the Act. So, for example, the Act creates a limited number of criminal offences, and this would only be if things have gone really badly wrong. So it's an offence to try and force somebody to enter into one of these arrangements against their will. It's an offence to put false information in any of the documents that come to us. It's an offence for any decision supporter to ill-treat or neglect the relevant person they're looking after. Now, this is only, as I say, if things have gone really badly wrong. Sometimes things do go wrong, but we expect that in the huge majority of cases, these arrangements can be made to work well. And we know that because people fundamentally and for the most part have the rights of a relevant person at heart. So these are some questions, and I'm nearly finished, that you might want to think about as we get ready in these last few weeks before the Act takes off. And all of these questions are from the point of view of the person, the relevant person. So what sort of decisions do I need to take? And at present, are decisions being taken by another person on my behalf? And actually, are these decisions that I can make for myself? Who can help me to do that? Do I need a decision support arrangement under the Act? And who can be my decision supporter if I do need one? That would be one of the formal arrangements under the Act. Can I plan ahead, thinking about enduring powers of attorney there or advanced healthcare directives? And then for that number of people who are wards of court, well, what are they to expect from the process? And more information is available from the Office of the Wards of Court, although you can find some of it via ourselves. And how to find out more, I'll say more about at the very end. So these are just some kind of takeaway considerations. And I'm thinking here about the UN Convention on the Rights of Persons with Disabilities. So that's an important international document to protect and uphold the rights of all persons with disability. And disability has a very broad meaning in that document. Ireland signed the UN Convention back in 2007 and finally ratified the UN Convention 4 years ago in the spring of 2018. And the effect of that convention is that we have to bring our own Irish laws and processes into compliance with the UN Convention. And the committee for that convention will check up on us and see what sort of job we are doing with that. And it has already been agreed that bringing to life the Assisted Decision-Making Capacity Act is an important part of complying with the UN Convention. And it emphasises these points. The UN Convention speaks about full human rights for all persons with disabilities without discrimination, the right to recognition everywhere as persons with disabilities as full persons before the law. Article 12 says that persons with disabilities have legal capacity on an equal basis with everyone else. And legal capacity refers to that ability, that entitlement to hold and to exercise rights. And loss of your decision-making capacity is certainly not an off switch for your rights. And how to find out more about all of this? Well, our website has been up and running for 1.5 years. As I said at the start, you will find on it a presentation very like this one. We are developing other information tools all the time. On Wednesday of this week, I'm going to be recording about 15 different explainer videos dealing in short segments with pieces of information about the Act. And you'll also find there frequently asked questions, tips for getting ready for the Act. And we are all the time developing our accessible information tools and how-to guides. I've mentioned that we are working primarily on a digital platform, so that if you're engaging with the DSS, finding out information, making one of these support arrangements, raising a complaint, filing a report, you'll do that primarily across our digital platform. And that was because we heard from people in other countries who said, look, if you're setting up a service like this, it's really important not to be dependent on paper-based and manual processes. And that kind of thing is changing all the time, as we all know. Very happy to have worked with Inclusion Ireland as well, who have mobilised focus groups for us and who are looking at our processes and our digital platform, and that's been hugely valuable. We must remember all the time, though, about accessibility. So that digital approach won't suit everybody. And with that in mind, we will have workarounds and alternatives.